Good afternoon. Happy New Year. For all of you who followed me last week, I'm sure you're um, curious as to how my brisket turned out. Since I did the show from my house, I had a brisket in the oven, and I could say it came out marvelous. My intent was to focus on OUIs because of the holiday season, and at least I usually see an influx of people getting stopped for operating under the influence. But it seems as though weed still takes number one billing. So just a couple of questions left from the marijuana. But I was notified by Michelle in my office today that they have pushed back the beginning of the retail sales from January 1st of 2018 to July. And essentially, lawmakers on Wednesday pushed through a surprise 6-month delay in the retail sale of marijuana for recreational use, saying that they needed more time to tinker with legalization measures that voters approved last month. They met during a holiday shortened week. The state's House and Senate voted to push back the licensing of cannabis shops from January 1st of 2018 to July 1st of the same year. So don't expect to find your marijuana shop on the street corner anytime soon. So it looks like it's going to be until at least the middle of 2018. A couple of other lingering questions. One comes from Chris. His question is, now that marijuana in your vehicle will be treated like alcohol as far as open container, will the smell of fresh or burnt marijuana again be probable cause to search your vehicle with this new law? I don't think that's accurate. I think a lit marijuana cigarette might be more akin to having somebody with an open container because of the ease of access with which you can drink an open beer can or a bottle of liquor. So I think it's more along the lines of if you had a bong going, or if you had a joint that was lit, I think that would be a little bit more of an issue. It's still not enough to get into a car, and certainly even less so now that it's legalized for purposes of probable cause. Certainly, if a police officer pulls you over and everybody in the car is smoking, and I would venture to guess that your meeting with that police officer might not go how you planned. So certainly you got to use good judgment whenever you're smoking, and I would recommend that you don't smoke and drive. It just probably make it easier on your life going forward if you decide that you're going to take advantage of the new marijuana laws. The other question I think came in from, well, how much do you charge for an open OUI case? A lot. Let's take a look at another one of these questions, and I'll go into OUIs and the simple EBCs of what happens if you get pulled over for an OUI. Let me just take a look if anything's live. It's kind of a work in progress. Public. Can you smoke weed in public? Can you walk down Main Street in Worcester and have a joint in your hand? No. You cannot smoke weed in public, just as though you would not drink alcohol from an open container and walking down Main Street. Joshua is asking me, what's a lot? I'd prefer not to answer those questions live, but hypothetically, if it was a first offense, you'd probably be looking at around $5,000 to do an OUI. So this is the holiday season, and let's say you and your wife head out and you go out for dinner, and each of you have had a couple of glasses of wine. You finish the bottle of wine. You get into the car. She makes you drive, and you're traveling maybe a mile, and all of a sudden you see blue lights in your rearview mirror. Think about driving by a speed trap. And knowing that you might be doing 68, 69, 70 miles an hour. Ramp it up about 100-fold, I would suspect. So when you are in the predicament that I just described, you are going to be extremely nervous. You are going to be probably in the most nervous you've ever been. So you've got to keep in mind that anything that you do from the point of stop to the point of arrest. And by the way, John, the Brady jersey is not for sale. So let's say you get pulled over. The moment the officer comes to the vehicle, actually before he's even pulled you over, let's say he sees you doing a mark lane violation, might be simple as speeding, or like I had this morning in East Brookfield, a client had gone down the wrong way for about 50 feet and had a broken tail light. You are basically on display for the officer. The moment the officer comes to your vehicle, you are going to be analyzed by that cop, and he is going to begin making judgments as to whether or not you're impaired, especially if it's a mark lanes violation, especially if it's late at night, and witching hours I call from 12 to 2 a.m. Those are when most OUIs I would suggest happen. I mean, while I'm going through this, I'll try to answer some questions as they come up. But so the police officer approaches. He makes observations of you, odor of alcohol on your breath, bloodshot and glassy eyes. Maybe your speech is a little slurred, maybe a little fidgety, and he's starting to question you. From this point forward, you need to know what your rights are. I would say to you as to what you can do and what you can't do going forward. Everybody has, by virtue of having a license, you're required to provide information to the police officer. Once the police officer makes a determination that he thinks that you might be impaired, in other words, he's got some probable cause to ask you to exit the vehicle, he's going to ask you to do one of a number of things. The first thing typically is he's going to watch you exit the vehicle. He's going to see how you do it. He's going to bring you to the rear of the police cruiser and watch you walk to the rear of the cruiser. And he's most likely going to ask you to do some field sobriety tests. The field sobriety test can be a number of different tests. For instance, in my case this morning, my client had a medical issue with his leg. So the officer gave 2 unusual tests for manual dexterity, this type of test and a number test. Both of those are not standardized tests that police officers were trained at the academy to do. So what are your rights? Let's say the officer says, I'd like you to do some field sobriety tests, and you say, no, I'm not going to do any field sobriety tests. If you feel as though you're impaired, and even if you don't think you're impaired, I guarantee you will not do any of the field sobriety tests perfectly. If you think you know the alphabet now, try to do them on the side of a road at 2 o'clock in the morning after having 2 glasses of wine, worked all day, and you're ramped up in terms of your nerves. You're not going to do it correctly. You have the right to refuse the field sobriety tests. Now, you're going to leave the officer with a couple of choices. He can then ask you to do a portable breath test just to confirm or deny whether or not you are impaired. And that test actually is the one I would take if I'm borderline and even not, because that kind of gives you a free shot at the apple, so to speak. You would take a test that's at the scene. Ultimately, it's not introducible in evidence at a trial, so they can only use it to determine whether or not to place you under arrest or to kick you free. If you blow a .04 or .05, the officer is just going to let you go, most likely, unless there was some other reason to hold you. But you have the absolute right to refuse everything. You can refuse that test too. If you refuse that portable test and you refuse the field sobriety test, you're probably going to be arrested. There's almost no thought in my mind that would tell me that if a police officer thinks that you're impaired and you're refusing everything, he's not going to play the safe route and place you under arrest. Now, what happens is you end up in custody. If it's a first offense, you'll be bailed out for $40, but it will give you an extremely strong case to win. Ultimately, you'll be asked to take a breath test, and again, you have an absolute right to refuse that test. recommendation would be almost always to refuse the breath test. It is much easier for a lawyer to win a case without a breath test over a .08 than and much more difficult to win a case with a breath test over a .08 than it is for a refusal. One of the main reasons is the refusal does not come into evidence. So the fact that you didn't take the test cannot be used against you in a court of law. So Kurt is asking, is denying field sobriety testing admissible in court? I think I touched on that, and they can't comment on it. Probably, I think only one of two states allow that. You would think a prosecutor would be able to, argue to a jury, why do you think he didn't take the breath test, or why do you think he didn't take the field sobriety test? Well, lucky you. You live in Massachusetts, and those two things are not allowed into court. So those are two big pieces of evidence that you don't have to give the Commonwealth when you are arrested. And trust me, anybody who's got a cop for a friend, a lawyer for a friend, really know all this. But you have to really be conscious of the fact that that might be the recommended thing to do, and you might consciously think about that before you go out. But if you have consumed a lot of alcohol, number one, you shouldn't be driving. But if you did decide to get into your car, ration goes out the wayside. So now you think a little bit differently. If you get to a point where you now think you can do all these field sobriety tests, like I said before, you're not going to be able to do them correctly, and you're going to have a more difficult time winning if the field sobriety tests are failure. Now, the benefits of, if you want to call them, taking a breath test, if you fail it, your initial suspension is 30 days. I have some clients who tell me I cannot deal with what the license suspension. I'll just deal with first offenses right now on a refusal, which is 6 months. It can be probably one of the most devastating misdemeanor offenses you can be arrested for, and it is really an equal opportunity crime. Teachers, priests, lawyers, judges, cops are not immune from this crime. So you have to go into it with the understanding that if you are trying to put yourself in the best position to win, and you shouldn't have been driving but you've been arrested, you need to exercise your rights. But you're going to end up with a 6-month suspension, and whether the case can be resolved before that 6-month suspension is up is, it's still up in the air depending on the court that you're in. Let me take a look and see if I can, any more questions. Thanks. What would you do if you were representing Michael Floyd? Well, if that happened in Massachusetts, and I've had cases many times where clients have fallen asleep at the wheel, either at an intersection. I had a case years ago on a third offense with an individual who had worked the entire day, probably 12 hours, had a second job in a restaurant, and then at about 2 o'clock in the morning in the middle of Auburn, had his foot on the pedal and gas and brake, and decided to take a nap. He was arrested. I had 2 individuals come in that could corroborate his work pattern, both at his main job and his secondary job, and the jury acquitted him. So I'm not saying that would happen in Michael Floyd's case. He looked pretty out of it. But it sure did look like he had some concussion-like symptoms, if you know what I mean. Kurt asks another question. Can you still be arrested if you blow below a .08? Yes, you will be arrested if you blow a .07, .06. They're going to arrest you. There's no inference either way once you go to court, but .07 will still get you arrested. Brandon asks, any way to get a prior OUI years off your old record? Absolutely. Great question. And OUIs are treated like any other misdemeanor. If you had an OUI that was continued without a finding, let's say, a year ago, upon that dismissal, you can seal your record. You'd have to petition the court that the case was in, and that can be sealed. If you have one that's very old, let's say if it's 8 or 9 or 10 years old, you can actually petition Boston directly to get that off your record. Now, It's still a first offense if it's a first offense that you're sealing, but it'll be off your query for most job applications, but it does not go off your motor vehicle history. The motor vehicle history will keep it as a first offense. So in Massachusetts, if you get another one, even if you have your first OUI sealed, you will still be charged as a second offense. Let me take a peek and see if I can find some more questions. Should my son get a lawyer for uninsured motor vehicle and number plate concealing ID? Well, I got to tell you, the number plate concealing ID is a felony, so you want to be real careful with that. Typically, on a first offense, anytime you're in court and you're dealing with motor vehicle laws, you should have a lawyer. It's safer to have a lawyer. Lawyers will be able to understand the suspension laws and what you might think is a great deal. And I'll give you, for instance, a lot of people get motor vehicle offenses decriminalized, but they're found responsible. So now you have a registry surcharge where sometimes a criminal matter being dismissed is better than something being decriminalized and being found responsible. Mike asks, should you take the breathalyzer? 99.5% of the times you should never do it. Let me take a peek if I have any more. And that's about it. So I hope everybody enjoys the new year. Keep in mind that police will, even though I don't believe there are any roadblocks this weekend, I try to post all the roadblocks. And I'm not doing anything that is illegal. I'm not doing anything that is unethical. I'm not doing anything that is improper. Actually, our laws require notice to the public as to an OUI roadblock. The one thing they don't require is the specific location, but they require to give you the actual county that the roadblock is in. So that would basically just repost what the state police send out as a alert. And the state police are required by law to alert the news media, newspapers, and whatever media outlets that they're required to do. But I just basically repost. Although I don't believe there are any this weekend, keep in mind that Saturday's New Year's Eve. So I would recommend, if you are going to go out, that you take some precautions before you get into your car, especially if you've consumed alcohol. Happy New Year, and I will see you next Friday. Bye-bye.